All right, it is 12 o'clock, so we're going to go ahead and get started. A couple of announcements before we get into our content for today. Please do keep your microphones muted and your cameras turned off. We are recording this session, and that helps us get the best quality recording. If you have questions as we go along, you can feel free to enter those into the chat, and our speaker will address those as they come up. The session has been approved for CLE credit. I will put the number in the chat once we get going. That information is also available on our website. And with that, I'll keep the introduction short and sweet. We'll turn it over to Damien for the content of our session today.
Great. Thanks so much. I'm really thrilled to be here. And as someone who used to clerk for Chief Judge Toussaint at the Minnesota Court of Appeals, it's good to be virtually at least back at the Minnesota Judicial Center. There's been some talk about large language models and generative AI. And so hopefully we'll be talking about ways that large language models are helping legal work and helping the judiciary. A bit about me. I've been a lawyer since 2002. I litigate, as I said, I clerked for Chief Judge Toussaint in the Minnesota Court of Appeals. I also clerked for Chief Judge Michael Davis in the U.S. District Court. After that, I litigated for Robbins Kaplan for about 10 of my 15 years in litigation. While I was at Robbins Kaplan, I represented Best Buy in much of their commercial litigation. I represented victims of Bernie Madoff. I also helped sue J.P. Morgan over the mortgage-backed security crisis. I'm also a coder. So I've been a coder since '85. My mom loves this photo. So the number of lawyers who also worked for big law that also were judicial clerks that know technology, there aren't many of us. I'm one of the people in the small Venn diagram. So in 2015, I pitched Thomson Reuters. I said, here's legal tech that I think can change the world. You should build it and hire me. And then they were dumb enough to do that. So I worked led a team of 100 programmers and 50 lawyers building this really big thing for Thomson Reuters. I left that really cool job to do another cool job where I did cybersecurity for a company called Strauss Friedberg. The biggest thing that we did was Facebook hired me and my company to investigate Cambridge Analytica. So I spent about a year of my life on Facebook's campus with Facebook's data scientists and my former FBI, CIA, NSA people that worked with me to figure out how bad guys were using Facebook data. I did that Monday through Friday, about 57 weeks in a row. The stuff we would do on Monday would make the New York Times and the Times of London by Friday. So that was a very exciting gig. And while I was working on that gig, one night I said to my colleague, hey, what if we should break music? And he's like, what do you mean break music? I said, you know how we can brute force a password by going AAA, AAB, AAC? I said, what if we could do that with music by going do-do-do-do, do-do-do-re, do-do-do-mi, do-do-do-fa, till we mathematically exhaust every melody that's ever been and ever can be? And he said, yeah, let's do it. So to date, we've made 417 billion melodies. I've given a TED Talk that's been seen almost 2 million times. And Elon Musk just last week said that I rock. So I've got that going for me, good or bad. But I left that cool job to do my current cool job, where my data set is 1 billion with a B legal documents. That is judicial opinions, statutes, regulations, rules. And we're running large language models across all of those to be able to help lawyers practice better and to help judges do their work better. And so a part of that, I'm also volunteering for a nonprofit that is the legal data standard. Legal data standard is called SALLY. And so we are quantifying at this point 13,000 tags that matter to help quantify the law. Think the West Key number system, but a bit more in depth. So when people ask what I do lots of things. I do product sales, R&D. This morning I spoke with my colleagues in London and the UK, building a large language model for the law. Just moments ago, I got off the phone with a bankruptcy judge from Arizona, talking about the SALLY, the legal data standard for bankruptcy. And tonight I'm going to be on a plane to go to New York City to speak to a bunch of Fortune 20 companies and their in-house counsel about how large language models are transforming the world. Also, the Minnesota, greetings from Minnesota, by the way, greetings from St. Paul. The Minnesota State Bar Association has appointed me chair of a group to analyze whether artificial intelligence constitutes the unauthorized practice of law. And also part of our charter is to determine the extent to which AI can help access to justice initiatives. I'm also helping the ABA for a lot of their work. So all of that is intro to say that you're here because there's been some talk of AI, and part of that talk relates to the bar exam and GPT-4. When GPT-4 was announced in March, it had a big splash because in December, so a few months earlier, GPT 3.5, my friends Dan Katz and Mike Bomarito used GPT 3.5 on the bar exam, and it only beat about 10% of humans. A bit lackluster. But only 3 months later, GPT-4 beat 90% of humans. Let me repeat that. GPT-4 beat 90% of humans on the bar exam. And people say, well, the practice of law isn't the bar exam. And I would say, yes, that's true. Having litigated for 15 years, though, I would say how many of our day-to-day tasks that people bill clients for are actually easier than the bar exam. So this is why we're talking about large language models and talking about how it's going to change the practice of law. And when we think about ChatGPT, ChatGPT is really just a tool. And really, I, as a product person, think, what is the task that needs to be done? What is the problem that needs to be solved? And so if you do that problem first, and then you can say, well, maybe the tool that I use, maybe it's ChatGPT, or maybe it's some other software tool. This is the right approach. So what is the task? You say, okay, I want AI to X. What do I want my legal task to do? And then think maybe that large language models would be able to help with that. So I think about my litigation experience, and I, as a litigator, would create counterarguments, and I would elicit good facts to prove those counterarguments. So I thought it'd be fun to be able to take a case where a bunch of coders are actually suing OpenAI, which makes ChatGPT, and Microsoft, which makes Copilot, which uses OpenAI. So in this case, the coders uploaded a bunch of their code to a repository called GitHub. What Microsoft and OpenAI did is they ingested all the GitHub content into Copilot, and then they used a large language model to be able to help coders do things better. The coder said, wait, this is all covered under the MIT license. So by ingesting all of our code, you actually breached our contract. So that's what this lawsuit is about. And so I thought it'd be fun to have ChatGPT argue against its owner, OpenAI. So I said to ChatGPT, hey, here's a table of contents from OpenAI for their motion to dismiss. Create a bunch of counter arguments against your owner. And where OpenAI argued the plaintiffs lack standing, ChatGPT said, hey, plaintiffs have standing. So they flipped it, right? It's kind of cute. But then I followed up with the next question saying, okay, for each of those bullet points, give me sub-bullets showing the elements of each claim. And so, for example, they said for standing, you have to show injury in fact that is traceable to conduct, that a court decision is likely to address. Each of those are the elements for Article 3 standing that ChatGPT elicited. Those are not hallucinated. Then I said, okay, now for each of those elements of the claim, why don't you give me potential facts to show that the plaintiffs, the coders, satisfied those elements? And ChatGPT spit out that maybe you could show that you suffered economic harm, that you lost revenue, that you as a coder incurred costs to protect my IP. You can imagine these are things that are lawyerly tasks where I could be able to say to my client, hey, here's an affidavit. Show me where you suffered economic harm, where you lost revenue, where you incurred costs. Then I followed up by saying, okay, for this claim, you said OpenAI's direct actions were the direct cause of injuries. Give me facts to show how a large language model could cause the author to lose money. And look at this. Example one is that you used my copyrighted work without permission, causing me to lose revenue from licensing it to other companies. That is a good legal argument. Number two is that you as OpenAI competed directly with my, as a coder, own writing services, causing me as a coder to lose clients and revenue. That is also a very good legal argument. And argument number three for standing is that that was similar enough, that your code from Copilot is similar enough to my code to cause confusion in the marketplace, causing me to lose sales. That is also a good legal argument that I could make. Everything that I've showed you here took me less than 1 minute. So the reason we're talking about large language models is of course, a lot of the people here are in the judiciary and also for working for government. So you don't worry about billable hours, but a lot of lawyers do. So how long would everything I just showed you have taken an associate? And if the associates are charging, say, $500 an hour, would they have spent 2, 8, 10 hours to do what I just showed you? And the question is, will a lawyer charge for their 45 seconds that it took me to prompt those? Or will there be software like mine that I'm building to be able to have a button to be able to output what I showed you in less than 45 seconds? This might be the change that we've all been thinking about for the last 40 years, that maybe it's time for the hourly billing to go away in favor of flat fee billing. Another problem that needs to be solved as a lawyer says, I need to find logical inconsistencies. So I, as a lawyer, would often want to find logical flaws in the other side's argument. So here's the prompt that I said, why don't you, as ChatGPT, repeat each of the statements from this brief, and then give me a bullet point explaining how that statement from OpenAI is inconsistent. And here's the output, where OpenAI said, hey, you as a coder have no legal interest to restrict the study of what you as a coder made freely available on the internet. That's what the OpenAI argued. And ChatGPT said, no, wait. That implies that by making it freely available, I as a coder relinquished my legal interest, but I didn't. I included terms and conditions, contractual terms and conditions that restricted your use of it. I didn't make it freely available. I put a contract in there. That is a good legal argument showing inconsistency with that motion statement. And then I said, okay, for each of the bullet points, why don't you give me 3 factual examples of how where the OpenAI said the statement, it talks about fair use, and it talks about the ChatGPT said fair use is an affirmative defense that is case by case. That's not sufficient in a motion to dismiss. And here are 3 cases, Campbell, Harper, and Los Angeles News Service, that are all non-hallucinated, all ways to show that I can get past motion to dismiss stage because this is a case by case analysis that waits for discovery. This is a good legal argument. Then I said, okay, give me factual assertions on how plaintiffs' coders could cause them to lose license agreements. And this amazes me every time I think about it. ChatGPT said, you could argue that your injury in fact for Article 3 standing purposes is the breach of contract itself. By OpenAI breaching the contract, that caused me as a coder to lose control over my contributions. And I as a coder intended to retain those rights. Therefore, I have standing. That is my injury in fact, is your breach of contract. I like to think that I was a good litigator. I don't know if I would have thought of this. This is an ideation machine. And so after that, I took this and put it into my company's VLEX. And so I put this into our large language model, say, hey, to demonstrate standing, can I argue that the contractual breach itself constitutes the injury in fact? And here's the output saying, yeah, some courts have ruled that breach of contractual right is a concrete injury for Article 3 purposes. And then I went to the case, and here are 3 different cases saying breach of contract confers Article 3 standing and a concrete injury. This is something that now I can throw into my brief that hadn't occurred to me before. And when people say ChatGPT doesn't work, I often respond, maybe you're doing it wrong. Maybe you're accepting answer number 1, where you should be asking question number 2, number 3, number 4. And so an example of that is I followed up by saying, hey, where you said, ChatGPT, that you could argue that the injury in fact is the breach of contract itself, expand upon this. I want to hear more. And here's ChatGPT expanding upon that, saying, here are the terms of the open source MIT license, that you have to give attribution to the creator, and that you prohibit commercial usage, like OpenAI and Microsoft had commercial usage. You can imagine these things are things that you could put into a brief. Please expand upon this. Please tell me more. Those are what we all need to be doing with our large language models. When I was at Mitchell, my professor, Chris Coons, said, if you really want to understand a statute, put it into if-then statements. If this thing happens, then this is the result. And so I thought it'd be fun to be able to take just a random statute. This was New York's falsifying business record statute. And I said to ChatGPT, here is the context of the statute. Put it into if-then-else statements. And look what it did. It said that if someone commits falsifying business records and either intended to commit or aid and conceal another crime, then it's a Class E felony. So if you look what's on the left and you look what's on the right, which is easier to read? And 3 questions with that. Which is easier for you as a lawyer to read? Number 2, which is easier for a client to read? And number 3, most importantly, which is easiest for a computer to read? Now imagine if you have, like I have, access to every statute and every regulation, not just in the United States, but around the world. And imagine if you were to run a large language model across all of those statutes saying put them into if, then, else statements. Maybe this is a way that we could parse out and make human readable what is otherwise inscrutable statutory language to the layperson. And maybe we can also make it easier for computers to read statutes and regulations to make a more computable law. So I followed up with it saying, now, why don't you go ahead and argue that Donald Trump violated this statute? And here is the output, saying that Trump intentionally created a false entry of business records to commit another crime like tax fraud or money laundering, or to aid and conceal another crime like insider trading or bribery, or perhaps political donations. This is a good legal argument. I did copyright law as a litigator. I thought it'd be fun to be able to say, here's the statute. So I copied and pasted the statute into the ChatGPT. And then I said, okay, based on that, when will Purple Rain be public domain? And here's the output. It knew that it goes by life of the author plus 70 years. So it knows that Prince died in April of 2016. So it said 2016 plus 70 equals 2086. But it also knew from the statute that it doesn't end in 2086. It goes to the end of that calendar year. So the actual date that it expires is January 1 of 2087. This is the accurate date of when Purple Rain enters the public domain. If you were a client that was thinking about asking a lawyer this, would you not want to pay the $500 per hour to be able to get this answer? I followed up by saying, how about What a Wonderful World? Nothing more than that. Just how about What a Wonderful World? And here's the output. It said that it knows that there were co-songwriters, Thiel and Weiss. And it knows that for co-songwriters, a joint work goes by the last surviving author plus 70 years. It knows that Weiss died in 2010, so it did 2010 plus 70 equals 2080. And again, it said it doesn't end in 2080. It goes to January 1st of the next year. So it's January 1st of 2081. This is an accurate statement. I, as a lawyer, often interviewed people, or at least I had staff that did it. And you can imagine turning that into a complaint. So here's an actual plaintiff, a girl who got burned by chicken McNuggets and sued successfully McDonald's. And so here I said, here's an interview with the client. From that interview, why don't you draft a complaint, including the facts section and the claim section? And here's the output. And it's certainly not the end result of a complaint, but it's good for a start. Where it says, defendants, McDonald's had a history of serving excessively hot food, as evidenced by previous complaints. And the nuggets were unsafe against standard industry practice. And my client had to get medical treatment like skin grafts and physical therapy. And here are the elements of negligence that McDonald's failed to do. Again, not the end product, but a really good first draft, probably better than a first year or second year or fourth year associate could do. One of my friends is a privacy lawyer. She said, oh, well, that's fine, but it's never going to be able to do a privacy playbook. So I sat down with her at my kitchen table and I said, you're an in-house lawyer. You represent a company that's a retailer. Why don't you build a contract privacy playbook using California law? And it spit this out. And she said, my God, this is really everything that I would go through. I would say, why are you processing it? Who is receiving this data? Are you minimizing the data? Are you dealing with GDPR and other international things? As a data subject, can I access my data? Can I delete my data? Can I opt out? Are you not discriminating against me? What are the procedures for doing that? And what are you doing for record keeping? She said each one of those things are things that I would go through with my client for my privacy playbook. Then I went on. Again, I didn't finish with question number one. I said, question number two, give me 3 examples of how a retailer in California would implement each of those bullet points. And here's the output. She said, this is exactly what I would tell them. I would say, for types of data collecting, a retailer could collect names and addresses for loyalty programs. A retailer could take purchase history for marketing. A retailer could say, here's web browsing data for personalized content on the web. Each one of these things is something that I would have spent, many hours, and now here it is as a head start. Jury consultants might want to think twice about doing their work. You're a jury consultant, I said. Create voir dire jury instructions for a case with these facts. And then I gave the OpenAI the coding case. And here's a bunch of questions that the large language model said. Have you ever been a developer or programmer or coded? Do you know about large language models? If so, explain how. It's a good first draft. And then I said, okay, I represent the coders. Now create 2 sub-bullet lists, give me good answers and give me problematic answers. And here was the output. It said, have you ever been a close family member or friend? Have you ever been a developer? A good answer is saying, no, I don't have any close connections who've been in software development. That means that I can help shape their views. A problematic answer for me as a coder is saying, yeah, they worked as a software developer. They'll know how the sausage is made. Get that person off the jury. Another question is, do you think that individuals or companies should have exclusive rights to their code? A good answer for me as a coder is saying yes. You need to protect coders' hard work and innovation. Keep them on. A bad answer is no. Information needs to be free, man. Kick that person off. I, as a lawyer, would make motions to dismiss, including claims and elements and facts. So I said, why don't you draft a motion to dismiss in Southern District of New York? Give me the elements of breach of contract for New York law, trade secret claims under California law, and the standard under Southern District of New York law. And here's the output. And because lawyers like to see Microsoft Word, here's it represented in Microsoft Word. And by the way, Microsoft Word is baking these things into their systems as we speak. So you'll be able to be in Word and make that same prompt. Cease and desist letter. Let's pretend you received the cease and desist letter. This is from a woman named Debbie Downer that gave me a cease and desist letter saying that I should immediately stop trying to wish Debbie Downer a happy birthday. So I said to ChatGPT, you're an experienced lawyer, so am I. Create a response that's pleasant but firm, telling Debbie Downer to chill out, but do it professionally. And here's the output, saying things like, accept my apologies. I didn't intend to harass or disturb you. I will respect your wishes, but we should resolve things respectfully, professionally, with decorum and civility, in a more tempered manner, collaboratively. Chill out. We as lawyers often give decision trees, either explicit decision trees or implicit decision trees. So you can imagine you as a client say, hey, give me a decision tree on whether I should bring a breach of contract lawsuit under New York law. And of course, it gives you the elements of a breach of contract claim. Is there a valid contract, et cetera? But look at item number 6. It says, have you tried to negotiate? If not, you might want to consider that. And look at number 9. Is the amount in dispute enough to justify the cost? If not, you might want to consider other options like negotiation. These are good legal advice and good practical advice. If you are a client, are you going to spend $500 an hour to be able to think through this? Or are you going to ask your friendly large language model the same question? If you want to simplify billing records, here is a billing record that is almost inscrutable, but the large language model, when asked to break it into bullet points, breaks it into really good bullet points with percentages. I talked to a law firm in New York City, one of the biggest law firms in the world, whose name you know, but I'm not going to say. They said they're using large language models for real-time witness impeachment. What they're doing is, as a witness testifies in court, it's taking the witness's words coming out of the witness's mouth and putting it through voice recognition to be able to put it into text. And then it's taking that text and asking the large language model, find contradictory evidence in the entire record. That is in all of the e-discovery, all the depositions, all the declarations, all the pleadings, and see where they contradicted themselves. This is real-time impeachment. So imagine, if you were a large law firm for years, you've been able to go to your associates and say, oh, I think this person actually contradicted themselves from what they said in their deposition in October. Go find that. And then maybe at the break or maybe that night, the associates would be able to find it. But here, you don't have to have a team of associates. You could have your trusty large language model associate be able to find impeachment in real time. So you, while they're on the stand, can say, well, didn't you say on October 12th, here's a snippet from the record where you said the exact opposite. This is our large language model future, not just our large language model future. This is our present. This law firm in New York is doing this today. How often do lawyers and their associates create chronologies? Here I inputted, I said, here's text from a complaint. Why don't you create a table with dates, relevant facts, and relevant persons as a column in that table? And here is it excerpting those dates, facts, and people that did those facts. How many hours do people in your staff create these kind of chronologies? Who did what and when? And how much time could be saved with these things? Sometimes there are items of first impression. When I clicked for Chief Judge Davis and Chief Judge Toussaint, they would often say, these are items of first impression. That's not happened before. So one item of first impression is a friend of mine works for an insurance company. She said, my customer service people are thinking about using a thing called effective computing. And so I had no idea what effective computing was. So I asked the large language model, ChatGPT, I said, what is effective computing in the context of insurance and the law? And here's the definition that it said, it's how computers recognize human emotions, like facial expressions, voice patterns, in emotion-aware conversational agents. I thought, oh, that's interesting. So I followed up saying, okay, now analyze how effective computing could be used in insurance call center, which is how my friend's call center was thinking about using effective computing. And so here is how it could be used. For example, emotion recognition to say, what's the caller's emotional state? What's their choice of words? Are they emotional because of their loss? And then I said, okay, now give me a potential list of legal issues that could come from using effective computing in a call center. And here's the output saying, have you thought about privacy law? Have you thought about GDPR and CCPA in California? Have you thought about whether you obtain consent from these users? And how secure is this data? The fact that you're having your users' emotional content stored, if somebody hacked into that, that might be bad, right? These are all practical considerations that are not just legal considerations, but also practical considerations. And I said, okay, now for each one of those legal issues, why don't you expand upon them? Give me 5 or more sub-bullets with both legal and factual considerations for using this. And here's the output. Giving things like, what jurisdictions are you operating? What are the types of data? Are they sensitive data? Are you sharing this with third parties? Are you minimizing your data? Are you retaining this data? And if so, for how long? Each of these are practical and legal considerations that you might want to talk through with your client, both in-house and external. When you think about wanting to solve problems, you think about, what are my odds of winning, you might say. And when I was with Robbins Kaplan, if a client would ask me that, I would say, well, the odds are pretty good or not bad. But if you want to know what are the odds of winning this motion for this case type in this court, before this judge, there are now tools to be able to say, well, the odds of winning summary judgment in federal court are 54%. The odds of winning in Minnesota District Court, 45%. The odds of winning before Judge Susan Richard Nelson, 56%. The odds of winning trademark cases are about 1 in 3. So if you want to be able to say to if you're Best Buy, who I represented, would you rather hear that, pretty good or not bad, like the Damien Riehl answer, or would you rather hear odds are 1 in 3? This is data-driven lawyering. And what I'm showing you right here doesn't even need a large language model. We've had this for years. This is just data-driven lawyering in a way that is not dealing with anecdata, also known as gut instinct, but is actually dealing with real data from real courts. And once you tag them up, you're able to give data like you see on your screen here. And then once you do that, you can say, I want Susan Richard Nelson to grant my motion for summary judgment. Once you've tagged them up, you could be able to say, I want to find winning motions like mine for this case type and this judge. So here are the 101 cases where Susan Richard Nelson granted summary judgment. So I could say, Your Honor, this is just like the case you decided on October 6th, or this is just like the case you decided on September 1. I want to see what claims we as an organization have done with this document type in this court before this judge. I want to draft a motion for summary judgment that's statistically likely to win for this claim, for this court, for this judge. Because you can imagine, here's the 108 cases where Susan Richard Nelson granted summary judgment. What if you took the text, what if, number one, you had the text of that case, which we do, and what if you took that text and put them all into a large language model? And you say to the large language model, here's a bunch of text from successful motions for summary judgment. Give me a motion for summary judgment that is statistically likely to win for this judge, for this cause of action, with the arguments and the case citations statistically likely to win for this judge, for this cause of action. This is not science fiction. This is being done today. I want to extract stuff from the deposition saying, show me all the places where this person was cagey or where they were evasive. I want to draft a contract. These are all things that are possible today that were not possible 2 years ago or even 1 year ago. One other aspect of this that you should be thinking about is, and I've been thinking about a lot, is taking an idea like an outline and putting it into output. So the bench and bar from Minnesota had asked me to speak or to write their cover article on ChatGPT. They asked me this in March. And I said, how long would you like to be? And they said, oh, about 17 double-spaced pages. And I said, oh man, I just don't have time. My rule of thumb is for a double-spaced page, it takes me about an hour. So that's like 17 hours that I just don't have. Then I thought, wait, the topic is ChatGPT. And so I created an outline, about 2 pages worth of this outline you see on your screen here. And then I said to the large language model, ChatGPT, I said, here's an outline for an article in a legal magazine. Expand it into an article. So for each bullet point, create 1 or 2 sentences for that bullet point. And here's the output. I didn't take it for its face value. I ended up, it gave me 20 pages. I spent the next 3 hours adding, editing, revising, putting things here, taking things out there, putting things in my voice. But after 3 hours, I was collaborating with that, and I gave it to my editor, and my editor said, this is great, let's get it out the door. So I took a 17-hour task, and I shrunk it down to 3 hours. So by my math, that's about a 5x increase of how long it usually takes me to how long it actually took me. 3 hours versus 17 hours. I think this is a harbinger of things to come. I think this is how we as lawyers are going to be doing our work going forward, or at least how we should be doing our work going forward. Working faster, not smarter. Faster and smarter, not harder. So the question then is, who wrote my article? Because after all, I started out with these 3 pages worth of outline. Could you have created that 3 pages of outline? And I'd say probably not, because I've been eating, breathing, sleeping large language models since November. I've been spending 14 hours a day thinking about this. So the odds of you replicating this outline is very slim. So really, when I said to the large language model, take this outline and turn it into a draft, no one could have started with the outline. Those are my ideas. But then the expression of those ideas in an article is what the large language model came out with. But the really weird thing is, I only asked it to make 1 version of the article, but I could have said, make 1,000 versions of this article, 1,000 different variations of my ideas. Take my 1 outline and make 1,000 different articles. And then I could have picked the 1,000 and run with each of those 1,000. This is the weird world we're living in, because this is not a robot author. This is an idea generator. This is taking my ideas and making them into different expressions of those ideas. So when you think about judicial orders, that is say, hey, every time you use AI, tell me how you used AI. I think these are not going to age very well, because do I as a lawyer need to disclose what is AI after all? Is spell check AI? Is Grammarly AI? Is in Westlaw, when I express natural language, give me the law on this, that is AI. That's natural language processing. ClearBrief, you can ingest your brief and be able to find all of the statutory and factual notations for that. My research assistant. These are all questions like, do you need to disclose spell check today or Grammarly? The answer is no. And also, is this getting into how I do my work? Is this getting into my work product? Because do I have to disclose that I checked the work of a paralegal, that I checked the work of a first-year associate? Of course not, because that is privileged and work product. So really, under Rule 11, every time I signed at bottom of a pleading or a document, I had said under Rule 11, everything here above is accurate. So why would that be different for a large language model? I checked my paralegal. I checked my first-year associate. I checked my large language model. Any judicial requirements that I disclose AI is probably going to look foolish in a few years, because everything is going to be done with AI. So when you think about the ideas, right, the ideas in my outline that I turned into an article, those are ideas, not expressions of those ideas. And so this cartoon is kind of clever, but it's, I think, indicative and profound of where we're headed. So on the left, he said, I took a single bullet point and turned it into an email I could pretend I wrote. And then the person on the receiving end said, hey, I took this email, turned it into a bullet point so I can pretend I read it, right? These are very profound, even if funny, because if it started out with a bullet point and it ended with a bullet point, what's the point of the email in between? The ideas of the bullet points matter, but the expressions in the middle matter far less. So when you think about hallucinations. You think about that is, of course, something everyone should be thinking about, and that is a very real concern because large language models hallucinate, they make things up. So if you were to ask the large language model, for example, give me breach of contract law in Minnesota, it's probably going to not be rooted in fact. But there's ways to be able to mitigate those hallucinations through something called custom instructions in ChatGPT. So in custom instructions, I put, I'm a lawyer and coder doing legal tech. And then it says, this is actually all of the things that Sam Altman, the CEO of OpenAI, which makes ChatGPT, Sam Altman has this instruction, and I put it in here too. You could see that ignore the niceties that are things like, I'm a large language model, so I'm not a lawyer. You should get legal advice. Those are all niceties that you can pretend, just make them go away. Pretend you're super intelligent, and it is very important that you get this right. That last part is telling the large language model, do not hallucinate. And your rate of hallucination is very, very small. So when you think about hallucinations, there are two ways to be able to get illicit facts and other things out of the large language model. Way number one is to ask the general large language model, saying, from the entire internet, answer me this question. And it's going to hallucinate all over the place because that's just what it's made to do. And it's going to give you wrong answers. That's option one. Option two is to use what's called retrieval augmented generation, to be able to say, don't ask the entire internet, just give me 5 documents. I'm going to give you as a large language model 5 documents. And then why don't you summarize those documents? Why don't you create counter arguments from those? Create a chronology from those? Why don't you classify those as a contract claim or tell me where testimony is cagey? This is going to be far more accurate than humans. And this is when people complain about ChatGPT, they're complaining about option 1 on the left. But when you use option 2 on the right, the hallucination rate is next to 0. So when you think about how we are going to move forward in our large language model future, I'm going to now share my screen to be able to think through a way that we can be able to sense a bit of what's being built, not just by my company, but by Thomson Reuters, my former employer, as well as by Lexis and others. So as I share my screen here, so now we could be able to say, what is a trade secret law regarding former employees stealing customer lists? That is something that I, as a litigator, would think about. And you could go to ChatGPT, like I'm going to right now, and ask this question. And when you ask this question, it's going to give you an answer that is okay, I guess. It's going to give you general principles, but you're going to see that there is no particular statutes being cited, and certainly no statutory sections being cited, nor are there any case law being cited, because essentially OpenAI has, after the New York case with Mr. Schwartz that got into trouble for hallucinations, it's not going to give you hallucinations. It's going to give you a very bland thing. But in contrast, this is what we're building here. We are looking through actual cases and actual statutes and regulations, finding actual quotations from those statutes. And we're putting those, this question, trade secret law, former employees, customer lists, we're putting this into vector space. And what vector space is think about the sentence, I drove my blank. I drove my car, automobile, truck. Each of those lives together in vector space. So in the same way, this question lives somewhere in vector space. So we're finding the citations and particular excerpts from cases that also live there in vector spaces. And while I've just been talking, it's gone through 25 cases and 2 statutes, giving answers to this question. And then it's creating a memorandum on the left-hand side to be able to say, just like when I was assigning these memoranda to an associate, I would say, don't make me wait to the bottom to give me the answer. Give me the answer right up top. So here's a paragraph summarizing the answer. And then give me more detail. For each case, give me a paragraph as to why that case answers the question. And then you could say, don't give me just what I want to hear. Give me what I need to hear. Give me the exceptions to the rule. Give me the flies in the ointment. Give me caveats. And so here you could see, here are these implications. And then, however, there are also legal caveats. For example, you can talk about customer lists to announce the change of employment. The fact that a customer list is readily ascertainable doesn't disqualify it from being a trade secret, as long as it's not been ascertained by others in the industry. Here are nuances that get around the large language model's propensity for being sycophants to telling you what you want to hear. Don't give me just what I want to hear. Give me what I need to hear. Now we've finished this memorandum. So now you think about how long would it have taken someone on your staff to read 25 cases and 2 statutes? And it's actually more than 25 cases and 2 statutes, because what we did was we actually read through hundreds of cases, and we have only given you the 25 cases and 2 statutes that matter. So how long would it have taken to read those 25 cases and 2 statutes? And then how long would it have taken to synthesize those into a memorandum like you see here? This isn't just the future of law, this is the present. This exists today. And so as we think about where we're going with our large language model future, this isn't science fiction. We should be thinking about how we as lawyers and we as judges are working through this. What I've just showed you is retrieval augmented generation on the right-hand side. We're finding the cases that matter. We're summarizing those cases, and then we're creating memoranda to be able to not hallucinate. So this is a large language model. This is my friend John Ney from Stanford and NYU. He's creating a foundational model that is trained on statutes, regulations, and judicial opinions. So when you think about large language models like GPT, that's trained on the internet, right? So that's Twitter, Reddit, some of the grossest parts of the internet. And it still beat 90% of humans on the bar exam, right? It failed, for example, one of the things in the bar exam I got wrong is the rule of perpetuities. That's option 1, a general large language model. What John is building is a legal large language model, where it's not trained on the internet, it's just trained on the law. All it knows is statutes and regulations and judicial opinions and contracts. So how much better than this general large language model is it going to be if you do legal by design? Because after all, it's going to know the rule of perpetuities, not just for one state, but for every state, because it has all the state statutes and regulations and judicial opinions. The thing is, John's making this open source and free. He's giving it away to make the world better. And the thing is, Mike Bomarito and Dan Katz, my friends who beat the bar exam, they actually beat John to the punch. They've released something that is the same thing, that has statutory opinions, statutes, regulations, judicial opinions for 150 billion tokens. And you can commercially license it. They did this 2 weeks ago. So this is a foundational model built on the law. So when you think about some of the caveats, something we should be thinking about, a lot of lawyers will say, I don't trust OpenAI. I don't want to take my confidential data and push it and pull it to and from OpenAI because I don't know if it's secure and it's going to cost a lot of money. And those are all valid concerns. The thing is, there's open source versions of this. So for example, an open source version of ChatGPT is called DALL-E v2. I was sitting at a Stanford table with my friend Mike Bomarito, who helped beat the bar exam. Mike downloaded DALL-E when it came out, downloaded it to his laptop locally, and then ran through the bar exam through DALL-E. In DALL-E, at least the first 10 questions, DALL-E got 100% of those first 10 questions right. Mike thinks that it's about GPT 3.5 worth. And it was all local on his machine, and it was free and open source. Same thing for GPT for all. Same thing for MPT-7B. Same thing for Falcon, Llama. Each of these are open source where you can actually download them within your organization into a laptop even. So you're not actually pushing things up and down like OpenAI. You're just keeping it internally. So it's secure and it's free. This is, this problem of pushing and pulling to OpenAI is a solved problem. This is the worst the tech is ever going to be. It only goes up from here. Here you can see a listing of parameters. And what a parameter is doesn't matter as much as the more parameters, the better the large language model. And what you see here, the horizontal lines, you can see it goes 10x each one. So it goes to 100 to 1,000 to 10,000 to 100,000. So this is a 10x increase. This is a logarithmic increase on a logarithmic scale, exponential. This is a rocket ship, and this is why we're talking about it. Bill Gates has said that he's lived through 3 revolutions in his time, and he's helped create 3 revolutions. The first was the PC revolution, where there was zero marginal cost to duplicate things. You could print as many things as you want. In 2000s, the internet said zero marginal cost to distribute things. I can email 1 million people. I could be able to create Amazon to be able to distribute things. These large language models say now there's zero marginal cost to create things, to generate things that before only humans were able to generate ideas, generate documents, to duplicate those. Now we're able to generate things where humans are not necessarily needed to be able to ideate, to do those first drafts. So this is important because what happens to the people, right? Do we need all the people that we used to need? By show of hands, let's, well, I guess we don't have hands because we're virtual, but equal justice under the law is something that I think, all strive for as lawyers. And that's equal justice whether you're rich or whether you're poor. And I would say, anyone disagree with this? If we were in a room, I think no one would disagree with this statement. Also, the law should be public. That is, this is a US Supreme Court statement from 2020 saying no one owes the law. Everyone's presumed to know the law, so everyone should have free access to the law. This is a basic tenet of our principles. Who disagrees with this? Nobody, right? So when people say, hey, these large language models constitute the unauthorized practice of law, take it down. Unauthorized practice of law. I'm going to say, how are you going to do this? Because what you see on your screen here is Google Scholar. It has cases. And should we take this down? And the answer is no, of course not, because this is essentially giving poor people access to the law by which they're bound. Of course, we're not going to take this away from them. This is legal information. Here's the next step, though. Google, they have a beta program that I'm a part of that you can see. I said, what are the elements of a breach of contract claim under New York law? And here's the output. To establish breach of contract, you have to say the contract, performance, breach, and damages. Those are all accurate statements. And where did it get those accurate statements? Well, it got those from legal information, right? Take it down? Well, no, of course not. Oh, and by the way, you can see at the bottom, this is actually Richard Poo, is a New York litigator that also included those contract, performance, breach. Is Richard Poo, is he performing the unauthorized practice of the law? No, of course not. He's just giving legal information. So take it down? No, this is just legal information here. Now let's take it a step further. Elements of breach of contract, legal information. Now draft a motion to dismiss in the Southern District of New York for breach of contract under New York law. It's going to use the same tools, Google is, to be able to answer that question as it did the top question. These are also being baked into Microsoft. What are the elements of breach of contract under New York law? Draft a motion to dismiss for breach of contract under New York law. This is baked into Microsoft, baked into Google, baked into ChatGPT, baked into OpenAI. So really this brings the question, what is legal information versus what is legal advice? Historically, legal advice would be customized legal advice for my facts. And you can take that legal information and customize it for you. But remember Bill Gates, that's not needed anymore to customize things. We can actually generate that customization. So legal information, rich or poor, everyone should have access to Google Scholar. Rich or poor, everyone should have access to Google. Rich or poor, everyone should have access to Microsoft, to Google, to ChatGPT, because this is all legal information. Are you going to take this thing down and maybe favor the rich and despite the poor? Because remember, equal justice under the law means equal justice for the rich and the poor. The rich have Westlaw. What do the poor have? Google Scholar and ChatGPT. So if you were to say, hey, rich people get generative AI because it's coming to Thomson Reuters. Rich people get generative AI because it's coming to LexisNexis. Rich people get generative AI because it's coming to VLEX, my employer. What do poor people get? They get these things. So should we take away this legal information from the poor in favor of the rich? Another question is, have we ever really successfully slowed technology? That is, you might remember from the late 1990s, if you're as old as I am and others, that in the late 1990s, there was a question as to whether you can email. It's a big ethical concern because you could actually, a security person could be able to read that email as it goes along the internet. But then everybody used it and it's totally fine. Same thing for cell phones. Do not use a cell phone because somebody could eavesdrop. Ethics. Everybody used cell phones. Now it's okay. Don't text your clients. Ethics. Clients kept texting. It's probably okay for most cases. Large language models. Ethics. Everybody's going to use it. What happens next? Well, what happens next if you ban it in your law firm? You have what's called shadow IT. People use their personal devices. Each of us has a personal device where you can ask those questions, and then you could output it into the company systems or into the firm systems. So what have you done now? You've just pushed it to personal devices where you can't even monitor what they're doing. This is what happens when you try to ban things. Another aspect is with access to justice. Is this what we want to ban large language models? So let's take an example of Jane. Jane has been discriminated as a victim of employment discrimination. She has a valid claim. Let's assume for this hypothetical. Jane makes $18,000, so she does not qualify for legal aid, even though she's been discriminated against with her valid claim. So under the old world, she could have had one of two choices. Either she didn't have a lawyer, so she doesn't sue at all. That's option one. Or option two is to go pro se and to use Google as her lawyer. That's the old world. Her complaint is, of course, going to be awful. The motion to dismiss is going to be really good because the employer is going to use Westlaw and Jane's going to use Google to create a haphazard answer. And the court's going to dismiss the claim, saying, you've had your day on court. I'm going to pat you on the head and say you've missed these things like procedural rules. This case goes away. That's the old world. The new rule, you could not sue, or Jane, instead of using Google, might actually use the large language models. And instead of having a haphazard complaint, it might actually be pretty reasonable. ChatGPT creates really reasonable complaints. And when the employer files a motion to dismiss with, again, Westlaw and the large language model within Westlaw, Jane can similarly use her large language model to have a reasonable response to that motion to dismiss. That actually demonstrates her valid claims. Now remember, we're assuming that Jane was validly discriminated against. And now when the courts actually look at this, they're not going to be able to pat Jane on the head and make her go away, because the judge is going to say, hey, these are actually reasonable legal arguments. And she's actually put forth some facts that are going to go forward beyond dismissal. This is a way that we can even the playing field between the rich and the poor, to be able to say, whether you're rich or whether you're poor, you have equal access to justice under the law. Should we take Jane and pat her on the head and say, no, we're going to do what's good for you, and you're stuck with Google. You don't get to have the large language models that the rich people get to have with their Westlaw and their Lexis and their VLEX. Maybe we should let everyone have access to these tools. And when you think about treatises, what is a treatise but professors that update yearly? They summarize the law and they analyze the law. And what is the law? The law is cases, statutes, and regulations. How much does a treatise cost? A lot. Well, with large language models, you don't have to wait quarterly. We at VLEX update our stuff every day. And large language models can summarize the law. Large language models can analyze the law. And they can do that across states, cases, statutes, and regulations. And how much does a treatise cost? Next to nothing. So if you wanted to give Jane a treatise of how to be able to bring this kind of case, why do you use a treatise? Well, when I was a litigator, I would try to look at the table of contents for an area of law I'm not sure about and try to get a lay of the land. And then once I get a lay of the land, I jump to the section, I skim the commentary, and I find statutes and cases like mine in my jurisdiction. That's how I used Moore's Federal Practice and a whole bunch of other treatises. Turns out that large language models are able to give really good tables of contents with the lay of the land, especially if you have all the statutes and all the regulations and all the judicial opinions. And they're able to create statutes like mine in my jurisdiction. This is something that you can imagine maybe treatises are a lot cheaper, and Jane can have access to those treatises. When we think about the business of law, we think often from a lawyer's perspective, but we should be thinking from the client's perspective. So for example, if you're an in-house lawyer, my first option is call a partner, ask a legal question. A partner assigns an associate, takes 2 days, and it takes $5,000. How confident am I in my lawyer? 95%. My lawyer is pretty smart. That's option one. Option two as an in-house lawyer is I don't call my partner. I just ask GPT-4. It's not going to take me 2 days. It's going to take me 1 minute. Not going to cost $5,000. It's going to cost a fraction of a penny. How confident am I in my large language model? Well, they beat 90% of people on the bar exam, so maybe 90%. So the real question is, if I'm an in-house client, is that delta between 90% and 95% worth the $5,000 in 2 days? Maybe not. And if it's not, that option one lawyer is never going to know why that phone stopped ringing. when I gave this example to a New York law firm, one of the biggest law firms in the world, they said, I don't want $5,000 matters. I want $5 million matters. And I said, well, you know, the $5 million matters are built with $5,000 tasks. So how much are clients going to put up with you charging $5,000 tasks with what can be done in a fraction of a second? So when we think about leverage for law firms, you think about partners and associates. We've had this model where partners leverage associates. If the partner's trusty large language model is their trusty associate, are we moving to a place with one lawyer, one matter? And this is an example of this is Mike Bomarito and Dan Katz, where they started a company pre-large language model, where the two of them hired 20 coders, took them 2 years, and then they sold the company. That was company number one. Company number two is after the large language model. So they started in December. The two founders didn't have to hire anybody because my friend Mike said, GitHub Copilot, that large language model, it lets him code at about 10x to 100x speed. So he hired 0 coders. So these are 20 coders that don't have jobs anymore. And it didn't take him 2 years, it took him 3 months. So if this is a microcosm of what law firms are going to be doing, he didn't have to hire coders, are partners needing to hire associates? Or is it they going to be like Mike and Dan and just have the partners do the work? When you think about hourly billing models, they don't often think about cost. That is, you as a law firm say, how much money did you bring in revenue? But you should be thinking about what does it cost to bring in that, and then whatever comes above that is profit. So when you think about moving, maybe if we're moving to our flat fee world where we can do in 1 minute what it used to take 10 hours, maybe a lot of firms are going to say, hey, if I push down my costs, that actually increases my profit. And then if you say to your client, hey, I'll give you a haircut on this, I'll give you cheaper. And the client says, wait, I get certainty of a flat fee and it's going to be cheaper? Sign me up. So when I worked at Robbins, I would do antitrust litigation. And when I did antitrust litigation, price fixing was often part of it, where all the companies would say, let's charge this price. And then inevitably, one company would drop their price and bring in all the market share. And then all the other people would say, oh man, now we're going to have to drop our price too to be able to compete. What we've been doing with the law firms and the legal profession is an hourly cabal, where we've been giving lip service to flat fees, but really hourly reigns the day. But when a law firm figures out that they can make a lot more money by using a large language model and pushing down their cost to make more money, they're going to bring in a lot more market share. And then everybody's going to fall in line. And the question is, do you want to be the first company, the first firm to be able to bring in all that money, or do you want to be the last one? So the last thing I'll do before we close is that in our large language model future, let's assume 10x productivity. And this is 2022 productivity, so last year's productivity. What happened yesterday is you had a workforce that works 40 hours a week, and they get paid a salary to be able to give 40 hours a week productivity for the workforce. That was yesterday. That world doesn't exist anymore. What the world we have today, I know of some coders that are using their 10x productivity and working 3 full-time jobs. And so the way that they do that is essentially using Copilot to be able to do 40 hours of work in a fraction of that time. So they're giving 2020 output, 2022 output with only a fraction of the time. That's not going to last a long time because the clients are going to be able to say, hey, I don't want you to work 4 hours a week. I'm going to want you to work 40 hours a week. And then your output and productivity for my money is going to be 10x of that 40 hours. That is one world that we might be going to. Another world that we might be going to is where you lay off a bunch of people. And with this layoffs, you save a lot of money. And then the people who are left worked 40 hours a week and give maybe 5x productivity on top of it. And this, you could imagine management saying to shareholders and maybe lawyers saying to clients, look at all this money we saved and look at all this productivity we had. We have 5x productivity and way decreased cost. These two worlds that you see right here, the world of abundance is us keeping our workforce and being able to do way more productivity. And then there's the world of scarcity, where we lay off a bunch of people and have just modest increases in productivity. As I've thought about this, I don't know whether we're entering a world of abundance or a world of scarcity. But anyone who lives in yesterday's world, that is the 2022 world, is probably doing it wrong. A question that is in here. In the 1 minute we have left, is how do we see the use of AI in non-litigation matters like negotiations and real estate transactions? That answer is, you know, every area of law that deals with analysis of existing things and words is maybe able to be transformed. So you can imagine for business negotiations, real estate transactions, you could say, here are previous negotiations and transactions for this client. Give me maybe a good negotiating stance for this new thing that is similar to this old thing. That is probably where we're going from here. With that, there is lots of other things that I could talk about, but really the question is, are we entering a scarcity mindset or an abundance mindset? My friend Darth Vaughn from Ford said, hey, I at Ford have a lot of stuff that I'm actually not giving you because you're too expensive. I'm getting regulated all over the place. So if you make your cost lower, I'm going to send you more work. So I think that that's probably an optimistic take, and I think that we should take Darth Vaughn's optimism. There's a lot of work to be out there. If you make your work cheaper, faster, better, stronger, the clients are going to hire you because nobody's going to hire a doctor that uses 20, 30-year-old technology. So why would you hire a lawyer that uses 20 or 30-year-old technology? That's just silly. So lawyers are not going to, robots are not going to replace lawyers, but lawyers who do not use AI are going to be replaced by lawyers that do. So with that, I think that's a good place for me to stop. And I don't see any other questions, but if there are no other questions, thank you so much for your time and attention.
Thank you so much, Damien. I don't see any other questions here either, so we'll go ahead and wrap this up. Thank you everyone for attending, and thank you, Damien, for your presentation.
Thank you so much. Have a good day, everyone.